I'm Michele Fuller, and I'm a special needs and settlement planning attorney based in Michigan. And I wanted to share with you some of the most exciting cases that I work on. And one of them that we just wrapped up is the Hawthorn case. And the Hawthorn Center, is one of the few mental health inpatient hospitals left in Michigan that treats minors. And so, what happened in this case is that about 2 years ago, there was an active shooter drill, and no one told the employees or the patients or their parents that it was just a drill. And so utter mayhem ensued, including police. It was incredibly traumatic for both the employees and the patients. Um, and so I was brought in to do the planning for the patient class. So what we were looking at is a class of 50 minors who had significant mental health issues that needed planning. We knew they were going to get a settlement. The Pitt McGee did a great job negotiating with the state. And one of the things that's unique about this case is that the defendant, the state of Michigan, is also in loco parentis, or they had wards of the state that were claimants. And so the state was basically suing itself. And so there was a lot of potential pitfalls in this case, and could have been a little tricky on the planning. And so I was so proud of the outcome of this case and being able to work with the great team at Pitt McGee to really maximize the recovery for the patient class. I think what's significant about this recovery for people, particularly the patient claimants that I provided work for and provided counseling for, is that the resolution or the settlement that they received is going into a special needs trust, which means, well, it's a particular kind. It's a pooled special needs trust. And it's really ideal for smaller recoveries, meaning under 500,000. So small is really relative. Somebody gave me $500,000 without having to get hurt to get it, I'd be thrilled. But that's not what happened here. And so with class actions, the recoveries tend to be a little bit on the smaller side because there's so many people and has to be spread among, this pot has to be spread among so many people. But I think what was interesting here in this case is that one, we had a lot of minors with significant mental health issues. And so navigating, probate versus where we were in the court of claims, and navigating, what the best vehicle was for this group of claimants to protect their public benefits. So all of them are on Medicaid. Some are on SSI or will be on SSI if they're at the point that they're not institutionalized. And so it was filled with landmines, this type of case. And so what was unique is that the plaintiff firm, Pitt McGee, allowed me to put out a request for proposal to a number of pooled trust providers. And so we were able to get a really deep dive into their operations, the parameters, like who works there, who's in charge of the money, what level of insurance do they have, what do their tax returns look like? So you may not know this, but a nonprofit, these are all nonprofits that run pooled special needs trust, their tax returns are public. That's part of what happens when you're a nonprofit, is that you have to make your 990s, your tax returns, public. And so asking for copies of those, and if they share fees, what their fee schedule is, really doing a deep dive into these organizations to make sure that, one, that they're going to be around for a long time, two, that they're very well run, very well insured, and the lowest fees possible. And so through that process, it's you would think, well, that's kind of normal, because business people think, well, of course you're going to get a number of quotes before. I mean, how many times do you get 3 quotes or more just to repair your roof or get a basement leak fixed? Well, that doesn't usually happen in class actions. And so this is one opportunity that we were able to do that. And so we were able to really narrow it down very quickly and make these organizations compete for the work, which means that they ended up with drastically reduced fees with a great organization that's very stable and around for a long time. And, even complying with the court rules, we were able to do it very quickly and efficiently. And Judge Redford, who was fantastic in the Court of Claims, very efficiently run courtroom. So everything just seemed to work and fall into place really well with this particular outcome. And so the overall outcome to the patient claimants is that we were able to maximize their recovery. So there were no fees or costs that came out of the individual claimant's recovery, which is, again, very unusual. Their overall fees for ongoing trust administration were extremely low and in a stable environment that protects the money for all of these minors and young adults so that it can only be used for them. There's no additional attorney or court fees that are coming out of these funds. It can all be used for them in their best interests. And by putting it in a pooled special needs trust, it preserves all of their access to government benefits, which they will need probably the rest of their lives. And so in talking with parents about this, they were thrilled because now they have access to specialists that are not otherwise covered under any kind of health insurance or Medicaid coverage. They were able to have access to tutoring or special schools that was otherwise not available. Young adults who were, without any kind of transportation, now they have access to potentially to buy their own car. And it meant stability, right, for them. Just this nice little pot that they have that can only be used for them. And so we were all of us on the litigation team, I think, were incredibly proud of the outcome of this case because we were able to do so much to preserve their access and keep their recovery intact as much as possible without any additional fees coming out of their recovery, which was, I think, a pretty extraordinary event. And so it was just really fantastic to be part of this litigation team and in conversations with these families, hearing firsthand how much it meant to them. And so just a little insight into what I get to do every day. Some of the considerations here were really important and impactful is that one, there was 50 people involved. Two, they were minors or young adults. Three, we are in the Court of Claims, which is basically the Court of Appeals. So anytime you're suing the state of Michigan, you have to do so in the Court of Appeals or Court of Claims. And so some of the other considerations is that they all have significant diagnosis with mental health disorders. Some are minors that have active parents, but a significant portion were wards of the state. And so some of the things that we did in order to navigate this is that the children who had active parents had their parent appointed next friend on their behalf. So because of that, that means that someone is appointed to act on their behalf during the course of the litigation. For those who are wards of the state, well, you're suing the state, right? So the Hawthorn case, again, this is a state-owned hospital. So we're suing the state, who is also basically acting as a parent for their wards, which was a significant portion of the claimants. And so I was really happy to work with Sanford Mall, who's a good friend of mine and excellent attorney. And he was appointed guardian ad litem to act on their behalf. And so it really helped to streamline and have a point person for them. And then we had some parents who were very active and others that needed a little prodding. What was surprising to me was that how many of these parents first thought that this was a scam. Like they didn't believe that it happened. Some of them didn't even know that the event occurred, or that their child really kind of endured this traumatic event. And so getting past that to make sure that they understood that, no, this was a real settlement. This was a real thing that happened to their child. And as a result, their child is entitled to compensation. So the tool of choice here that we use to help protect the kids is a pooled special needs trust. So what that does is that, so when you have means tested public benefits, those are benefits that you have to meet medical criteria for and a financial criteria to have access to those benefits. So one, you have to be a person with disabilities and meet that Social Security definition of disability. And two, that means you have to basically be poor, very low income and less than $2,000 in countable resources. And this is true for SSI. And until recently, there's a proposed legislation change in Michigan that would allow someone who's on Medicaid only to have a greater number of resources, around $9,430. But that legislation has not passed yet. So we were still working under the $2,000 asset limit. That means it's all the stuff that you can have, all the cash that you can have out of all of your accounts, no matter where your money is, including cash. You're only allowed to have $2,000 or less. And so working under those parameters, and then on top of that, we had minors. And so the tool of choice here is the pooled special needs trust. And after much vetting and negotiations, we chose CPT. They are a great national provider, very stable organization, been around for a long time with some of the lowest fees in the country. And so, and also under the circumstances, they further reduced their fees in consideration for these injured children. And so because of that, because it's a pooled trust, we were able to utilize the authority of the guardian ad litem for children on behalf of who are wards of the state to be able to advocate on their behalf, to be able to complete all of these documents, to be able to have their funds secure and protected, but yet allow them access. One of the unique things about CPT and the way that they administer their pooled special needs trust is that they have a beneficiary advocate. And for the kids who had active parents who were acting as next friend, they were naturally electing to be the beneficiary advocate. And the role of the beneficiary advocate is to be that liaison between the beneficiary and the trustee to make sure that the beneficiary is using their funds in an appropriate way, meaning in a way that won't violate government benefits. And so, the money doesn't do any good if they don't even know it exists or it's been set aside for them. And so that was an important consideration for every claimant, but in particular, this group of people. So we have active parents who know about the funds. And one of the things that the trustee does is make sure that any request for bill payment or any kind of disbursement is, one, compliant with government benefits, and two, is in the person's best interests, and three, for their sole benefit or for their primary benefit. So it is absolutely protected. But what's really important here is for the wards of the state. So these young adults are either, institutionalized, or they're with foster families or foster care, or some of them actually turned into legal adults over age of 18. And so their needs were even greater. And so who's there to make sure that someone is telling these kids that this money has been set aside for them? Well, because of the way that CPT administers this trust and the beneficiary advocate, we had an independent professional fiduciary, Charlene Disler, who is part of and owns Probate Support Specialists. She was the court-appointed beneficiary advocate, and she is the liaison between the state foster care worker, the beneficiary, and their foster care family, and the trustee to make sure that these kids are, one, aware that they have this money set aside and is advocating on their behalf. And so I think that was one interesting, important development, and one of the reasons that we chose CPT, that they are really well suited to do this type of work. And they've been around for a long time, but I think that's unique to this organization, and it really worked well in this case. Some of the biggest challenges in planning for 50 minors, with a substantial number of them being in the state's care, is that, one, they're minors. There are special rules when you are in the court that's designed to protect minors who are undergoing litigation, especially for personal injury settlements or personal injury cause of action. And so that is a challenge. The other challenge is that there's 50 of them. And so getting information is difficult. And as I mentioned earlier, one of the biggest challenges is that a lot of these parents thought it was a scam. I mean, can you imagine how many pieces of junk mail everybody's on guard? And it does appear a little scammy, like, hey, I'm Michele Fuller from Michigan Law Firm. I've got money for your child, but I need their social security number and date of birth. I mean, yeah, it's a little scammy. But the good thing is that there was some news coverage on this event. And so I was able to share with them, like, no, this is legitimate. Here's who I am. Here's my firm. Check me out. This is legitimate. And so getting past that was an important hurdle, I think. When it came to the state wards, that was, I think, a lot of the red tape and a lot of the issues there were able to be worked on through the appointment of a guardian ad litem. So a guardian ad litem is basically a guardian for the day. And that's where the court appoints an independent professional, usually an attorney, to act on behalf of someone who needs protection. And it's usually a minor or a person with disabilities who's an adult. Not just a person with disabilities, but someone who's actually lacking legal capacity. So that means that anyone who can't make decisions for themselves. And so because of that appointment, that was incredibly important because the state is basically, they'd be suing themselves. And so we needed to mitigate that conflict of interest. And so that's where Sandy Mall just did a fantastic job in making sure that all the minors were protected and really communicating with the state, the foster care agency, and everybody already knows that they're overworked, right? Their caseload is immense. And so getting their attention was also a bit of a challenge because it's only 50 kids when they're in charge of so many. And it's a position that rotates a lot. So the foster care worker that was here, when the state took their census and said, okay, this person is appointed to act on behalf of this minor, 2 months later, half of those people have rotated out and onto other departments or no longer represent that child. And so that was a bit of a challenge. But everyone involved in this case, whether it was on behalf of the state or whether it was on behalf of the litigation firms, everybody was really pulling together to help protect the minors and make sure that they were going to maximize their recovery. And so I think that is a little unusual, where usually defendants don't care. Companies, organizations, they don't have any vested interest in the outcome of a case, especially protecting a plaintiff. Not usually anyway, but in this case, the state did have a vested interest in making sure that the outcome for the kids particularly was maximized and that the kids were well protected. So one of the other elements here is that we were able to avoid additional probate court involvement because of the type of trust that we used, and which is that pooled special needs trust. So we weren't creating a new trust. We were just allowing them to participate in a trust that has existed for many years and already approved through Social Security and Medicaid as an exempt resource. So I remember we talked about that asset limit, that $2,000 asset limit. Placing funds into a special needs trust protects that. And it's kind of like a clear box. The government needs to know about it. They need to know that you have it, that it exists, how much is in there, and they can ask questions about the disbursements and how you're using that trust at any time because they're providing government benefits to someone that now has resources. But we call those exempt resources because the state knows about it, but they can't use it when they're considering financial eligibility. And that's really, really important. And so, because of the underlying facts in this case, all of the kids have had at least a mental crisis or have ongoing mental health support needs. And so what's kind of typical in this population is that they'll come in and out of eligibility, in and out of disability qualification. And so this condition tends to be cyclical. depends on compliance, management, health, hormones. So many different factors are part of this, but regardless, their funds are protected as they go on with their lives and do their best to make their way in the world. Some of the lessons I think that would be helpful to litigation attorneys or even settlement planning attorneys is that, one, involve the settlement planning attorney, somebody with my type of background that specializes in public benefits and planning for people with disabilities, that is a probate expert, that knows all of the rules and knows vendors and knows some of the resources. Bring that person in early because it makes a big difference. Begin as you mean to go on. So one of the things is that if there's a registration process when you have a class action, and there's usually outside vendors that help to create websites where people can register their claims. I think all of us have probably gotten a postcard in the mail or some sort of letter saying, hey, you have a potential cause of action in this big settlement. Go to this website to go register your claim. Well, one of the lessons that I would have is that there's some sensitive information that is potentially difficult to collect, like social security numbers, dates of birth, other identifying, driver's licenses, state ID, things like that. Having a secure portal to collect that information early in the process is huge. And I wish that could have been done in this case, but it wasn't. And so that's a lesson, I think, that collaborating early in the process with someone with the background that I have, I know what information is needed down the line that is difficult to collect. So collecting that at the front, at the beginning of litigation is huge, hugely helpful. The other is, I think in this world, basically, overcoming cynicism. And this is not a scam. Getting people to move forward, even when they don't, especially like parents, when they're not personally benefiting, can be a challenge. And in most cases, the parents were really helpful, but they've also undergone trauma. I mean, they've had a very challenging experience trying to raise a child with significant mental health issues. And so I think having a large degree of empathy and compassion for not just the claimants themselves, but the people who support them is incredibly important. Some of the other lessons I think here, most importantly, would be doing a request for proposal, making the vendors, be transparent about their fees, who's involved, their safety protocols, their security protocols, is really important for life after settlement, because this isn't just, solving the immediate issue of how do we get people their money in a safe way and protect their benefits. This is also ongoing protections and how do we maximize the settlement so it actually makes a difference in their lives after the settlement is complete. And so I think with all of those considerations, I think we did a really good job in this case in particular, including the appointment of a beneficiary advocate. It's one thing when you have a family member who's willing to step up and do it, but when you have wards of the state who can easily get lost in the system and, with the ever-changing role of that foster care appointment, foster care worker, that money could very well just sit there and not work for that person. They may never know it's there, which would be really awful. That's not a good result, and that is not what we're working for. But I think critically here, we have that professional, independent fiduciary appointment whose specific task is to be that liaison. And I think that's a critical element of the success of this case. Just some general advice to litigation attorneys and families who have children with disabilities or loved ones that are incapacitated adults that they're advocating for. I think one is select the right attorney to work with. I don't mean just on the plaintiff side, on the litigation, the personal injury attorney. I mean on the planning side. And what you want to look for is somebody who has a lot of probate and estate planning experience, who has expertise and a deep knowledge of public benefits and has resources. Ask what their background is. Ask how many trusts they do, right? How many special needs trusts? How many settlement preservation trusts have they done? Is this something they do every week? Is this something they do once in a while? And what are their resources that they can bring to the table? And so special needs planning isn't just a matter of being able to draft a well-written special needs trust. It's about bringing those resources together, identifying potential bumps in the road, and maximizing that person's recovery. So with a minimum of ongoing expenses. And that's part of the maximization. And so I think that's really, really important to know who is doing the planning. I know that there's companies out there that don't necessarily have an attorney in their background. It's more finance related. But I think that the attorney plays a really important role, especially if they don't sell financial products, because they don't have a vested interest in the financial outcome. They're being paid for their expertise, which is bringing all these resources together. And the financial piece of things is incredibly important. But in my opinion, it should be the goals of the client headed by the legal team, along with the financial component. But I think that legal planning, that expertise is really key, because we can, are we able to avoid unnecessary court proceedings, unnecessary expenses in the beginning and ongoing? Are we able to negotiate with providers, like trustees, ongoing administration? Are we having potential providers or vendors compete for the work, including investment advisors? All those fees are negotiable. And when I, as a planner, or people who do what I do, are advocating for people, that's what we are doing. We're kind of like CPAs, right? In a way, in the tax world. A CPA is helping you pay using all the tools at their disposal to crunch the numbers to have you pay the least tax that you owe. And there's some planning. There's an art to that. There's an art to what I do. And so we should be actively negotiating fees. We should be actively making people who are providing goods and services to compete for that business. And so that's a really critical role that someone like me can play, that special needs and settlement planning attorney can play at the very beginning and ongoing, to make sure that life after settlement, that the funds are impactful and make a difference in that person's life. So this is Michele Fuller, and I hope that you found this as interesting as I do. I know that I'm so proud to have worked on this case and the outcome for each of these patient class claimants. And I hope that you found it interesting. We're going to have more interesting tidbits as this goes on. If you have questions, feel free to reach out. If you want to hear more and don't want to miss an episode, feel free to subscribe. But thanks so much for listening.